Right. Good afternoon, everyone. So we have to start from here today. The last part of banker customer relationship, that is termination of banker customer relationship. Right. You remember that we discussed under the banker customer relationship subtopics. We discuss who is a banker, what is banking business, what is the nature of the banker customer relationship, and then thereafter the banker's rights and duties, customers rights and duties, and also now the last part is uh, termination of banker customer relationship. Right, under this uh, we'll see how can a banker customer relationship can be seized or stopped. The first way is the death or insolvency of the customer or lunacy of the customer. Lunacy means the mental illness of the customer. We'll see how this could happen. Now, take an individual customer. You know, when we say the banker customer relationship, we said the basic nature of the banker customer relationship or fundamental nature of the banker customer relationship is contractual relationship. It's a contractual relationship. So, in this contractual relationship, there are two parties. That is, those are a customer from one side, and the other side, the bank. If an individual customer open an account, he creates a contract with the bank. So, with the death of that individual person, the banker customer relationship comes to end. So thereafter, you can't, if a customer is dead, then thereafter there's no contractual relationship. So at what point the contractual relationship stopped? It is the point that the customer did. So remember that. So for all relationship, all transactions, whatever the transaction occurred after the death of the customer is legally not valid because there's no contractual relationship afterward. The insolvency also a method or a situation where the banker customer relationship can be ceased. Insolvency means that person, individual, uh, uh, basically bankrupt. So then thereafter that person cannot, he doesn't have a civil right to enter into any kind of contractual relationship. So therefore, if that person is insolvent, if the court of law declare that person as an insolvent person, then thereafter he cannot maintain the banker customer relationship. Basically, the banker customer relationship comes to end. Then third one, the lunacy, as we are aware, since the banker customer relationship is a contractual relationship, under the contractual law, contract law, we discuss there's an element called contractual capacity. If any party does not have the contractual capacity, then he cannot enter into a contract. If a party who has entered into a contract lose the contractual capacity, then what happens? The contract comes to end. So likewise, in here, after creating a contract with the bank, if customer get a mental illness where he can't understand what he is doing and all, so then that he doesn't have a contractual capacity anymore. So therefore, the contract, the banker customer contract, comes to end with the lunacy of the customer. These three things that we discuss are relevant to an individual customer. What about a company? If it is a company, we know that company, since it is not a natural person, can't die. So lunacy is not applicable. So, however, if if a company, that is a corporate customer, if a company is liquidated, then the banker customer relationship comes to end from that point onwards. Liquidation means the company basically comes to end, or it's the death of the company. So liquidation process is a complicated process. The company has to go for a voluntary winding up, or a creditor or interested party can go for a liquidation of the company by filing of action. However, if the company is liquidated or wound up, then at that point onwards, the contractual capacity comes to end of the company. So therefore, the banker-customer relationship comes to end from that point onward. That is the second method, the banker-customer relationship comes to end. Then third one, the customer closing the account, that is voluntary termination of the banker-customer relationship. So as we discussed last occasion, the customer has a right to close his account. You may remember that I mentioned last day, the customer has a right to close his account at any given time. So basically, he can come to the branch and just close his account by just giving notice without any prior notice. So therefore, that is one method that the customer-banker relationship comes to end by voluntary termination of the contract. Then the fourth one, the closing of the account by the bank, that is after giving due notice. The bank also has a right to close the account and terminate the contractual relationship between the bank and the customer. But the difference here is the bank has to give due notice before we closing the account. However, if we close the account after giving due notice, then the contract comes to end. What is the due notice and all that we are going to discuss in few minutes time. So for the time being, remember the bank has to give due notice. If you give due notice and close the account, then the banker-customer relationship comes to end from that point onward. Then the completion of the contract or specific transaction. Now remember, in certain situations, certain circumstances, between the banker and the customer, there can be a specific contract. Specific contract means that the contract is maybe for a specific purpose, or for a specific time period. For example, take a fixed deposit. We assume that this customer has only a fixed deposit with us. We assume he doesn't have any other relationship, any other contract with the bank, only a fixed deposit. So fixed deposit is a special contract. It's valid for a period of time. We say the customer has deposited money in a fixed deposit, which has the maturity period of 1 year. So what happened afterwards? Unless the contract or the fixed deposit renew automatically, what happened at the end of the period, that is 1 year period, the special contract comes to end. Automatically it comes to end. So then the banker-customer relationship comes to end at that point onwards. So there can be a circumstances where a customer enter into a contract with the bank for a specific transaction. For example, we assume that the customer obtain a bank guarantee. He doesn't have any other the facility or any other contract with the bank, only that he's an importer. He wants a bank guarantee. So for that specific transaction, he entered into a contract with the bank. So the bank issued a bank guarantee. So after accomplish the transaction, then that contract comes to end. Thereafter, no contractual relationship between the banker and the customer. So these are the methods that a banker customer relationship can comes to end or can cease. If you have any questions from this, you can ask now. Everyone clear how we can cease the banker customer relationship?
Sir, I have a doubt.
Yes.
In the previous session, not this. Shall I ask now?
Yeah, yes. Okay. If it, yeah, tell me.
In the last session, sir, the duty of customers, the last one, customers' duty to check and
Yes.
that one in the note, customer has no duty mentioned like that.
Yes.
So, how it comes duties of customer?
No. Okay.
No duty.
It is not a. In fact, I explained that day that it is actually not a duty. You see, but there are circumstances, situations where the bank send account statement printing certain conditions, like the customer has to check the account statement, and if there are any irregularities or mismatch, the customer has to bring to the notice of the bank, and the customer has to rectify such errors. So likewise, the bank put condition. The question is, when a clause like that, or when a condition that when the condition is put by the bank to the customer, whether the customer has a duty, right? That is the question. That was answered by court of law. The court of law said that the bank cannot impose conditions like that on the customer, extra conditions on the customer, or duties on the customer. It is not the duty of the customer actually to reconcile his account or check his accounts statement. So remember, even though I discussed that under that topic, you have to remember it is not a duty, right? It is not a duty. He has a duty of care when he is giving written instructions. He has a duty to inform the bank when there is a fraud in his account, if he knows any fraud, but he doesn't have any duty to check his account statement and inform the bank for any irregularities of the account. So, are you clear?
Yes, sir. Thank you.
Okay, right. So, any questions from this slide? Termination of
So what
bank
is
account?
liquidation, sir?
Huh?
So what is liquidation? Can you please tell me?
Okay, liquidation, the company is a legal entity. It's not a natural person, right? A legal person, you create the person by following a procedure and then create a person. So, for example, company, if it is a company, you know that under the Companies Act, by following the procedures of the Companies Act, you can register a company at the Registrars of Companies Department. So then once you register the company, that company or the entity is considered as a legal person. So the legal person, he can enter into a contract with other legal persons or also natural persons. So therefore, a company can enter into a contract with a bank. So they can open an account with in a bank. So if it is a contract, if it is a company, a legal entity, how a company can or the contract between the company and the bank can comes to end. So if it is a natural person, by death of the person, that contract comes to end. But when it comes to company, since it is not a natural person, there's no death. The liquidation means the company can be close down the business. not only the business, the company can be company can be wound up or closed down by applying a legal procedure. How you apply, how you wound up the company? You go to the creditor or any interested party can file action in court of law. Then thereafter, the court of law will give an order after the inquiry to wind up the company. So close down the company. So after closing the winding up the company, there is no company under that name. So that procedure is called liquidation. So once the company is liquidated, the company is no more in existence. There's no person like that. So when there's no person, the contract that he has entered before also comes to end. That is called liquidation. In Sinhala, we call this Ganan Bera Vasademi. So basically, liquidation means company Samagama Vasademi. So are you clear?
Yes, sir. Thank you, sir.
Right. Any other questions?
Excuse me, sir.
Good afternoon, sir.
Yeah, good afternoon. There are two.
So I have a doubt.
Yes. Yeah, what is it?
Shall I ask, sir?
Yeah, sure. Ask.
How banker sees the customer account, sir?
How bankers seize the customer? You mean the close the account or seize the account?
Yeah. Sees the account.
Okay. Right. I will explain. The banker actually cannot seize the account. Banker can close the account, but banker cannot seize the account. Banker has to seize the account when you get a court order to seize the account. Seize the account means that you have to freeze both credit and debits. Basically, no transaction can be done when the account is seized. Otherwise, if customer is dead, from that point onward, the legally or literally we say the account is seized. So thereafter, the account is not in function. So basically, you can't function any debit and credit. Cease in the sense here, cease means stopping the banker-customer relationship. How we can stop the banker-customer relationship or end the banker-customer relationship is by closing the account. Banker has a right to close the account and terminate the banker-customer relationship. Ceasing is another legal principle where a legal body or legal authority, example courts, issue an order to seize the transaction, debit and credit. So that is called seizing. Seizing and stopping or terminating, these are three different scenarios or principles. So basically, you have to understand the differences between seizing transaction, terminating the relationship, and freezing the account, so on. So these words are legal words. So therefore, the principle behind that you have to understand. Are you clear, or you want more clarification?
Yes, sir, I understood. I have another doubt also.
Yes.
Sir, if the customer dies,
Yes.
the customer's family can be used the account, or the family want to create another account in the same bank?
Okay, good question. Once the customer is dead, banker-customer relationship comes to end, that account comes to end. Basically, no one can maintain that account thereafter. Legal spouse or children, no one can continue the account. So basically, it comes to end. The account comes to end. It's a permanent thing. It can't reopen. So that's number one. Then the second question you asked, whether the legal heirs or the family members, whether they have to open another account. On behalf of the dead person, no one can open the account, number one. So what will happen to the money in the account of the the dead person. That is the issue, no? So issue then, if the money in the account is over 4 million, the legal heirs, they have to go to courts and file a testamentary action. Then they have to bring a court order. As per the court order, we will release the money to the legal heirs as per the court order. If court order says the money, entire money should go to the wife or husband of the deceased customer, we will release that money to the wife or husband. If he wants to open an account under his name in our bank, okay, he can, because he has a contractual capacity. He can open an account under his name. Then we can transfer the funds to his account, or we can issue a bank draft to that person if the account carries over 4 million. If it is less than 4 million, then there is a procedure that that under the common law of the country, half of the money will go to the wife and the rest will go to the children. So then if the total value of the money, or total value of the money, not only this account, the assets in the bank is below 4 million, then we can get the death certificate, affidavit from the legal spouse and the children, and a copy of the marriage certificate, copies of the birth certificates of the children, and then thereafter we can issue checks or bank draft. Half of the money will go to the wife, then the other half will be divided equally among the children. We say we have 3 children, then each child get 1/6 of the money of the deceased customer. Clear?
Yes, sir. Clear. Thank you.
Right. So there was another question asked by another gentleman. Yes.
Yes. So let's say if Mr. A and B have an account with a bank, joint account with a bank. So as per the operating instruction, Mr. A is the authorized signatory. Let's say in case of disease of Mr. A, how will it affect to the bank customer relationship, end of the bank customer relationship?
Okay, good question. Very good question. It's about joint account, right? Joint account. Remember, if it is a joint account, whatever the money in the account belongs to the both. Belongs to the both. Basically, it's not half, right? There is a principle called survivorship principle. Survivorship principle means when there are joint account holders, if one deceased, the other one get the entire thing. That is called survivorship principle. So under that principle, if the account is maintained by A and B, if A is deceased, irrespective of whether he is the authorized signatory or not, the money will go to the B. So the best way to handle the matter is, we can ask B to open a separate account under his name, individual account, and transfer this money to that account. Or if it is possible in your system, that you can convert the account into an individual account. But best way is ask him to open an account and transfer that money to his account. Clear?
Yes, thank you, sir.
Okay, any other questions?
Sir, I have another account in the liquidation. If
Yes.
the customer not in a position to settle the loans and all, according to the liquidation, the company at the moment don't have any liquid facility, right? So in that case, is he has to pay all the loans, and after that only we allowed to close the account?
I think your question, you say that we have given the facilities to the company. Company is not in a position to pay. The company wants to wind up, and your question is whether we can allow them to wind up the company after paying all the debt to the bank. Is that the question?
Yeah, sir. Now on it's come to my mind. We have anyway have asset, no, so we can recover from that. Is it?
Yes, if it's like this, if right, since you asked that question, I will just go through the liquidation process also a little bit because it is important to the bankers. If it is a company, remember when you are lending to in a company, you are running a risk. If the company cannot pay the debt to the bank, if they or any creditor of that company filed action in court of law to liquidate the company, then we can't start our recovery process. That is the danger that we carry. Basically, when the liquidation process is started, what we have to do is we have to go to courts and we have to lodge our claim in the liquidation action, right? Irrespective who has filed it, we have to go and file our claim. So normally when the liquidation action is filed, they file paper articles, paper advertisement, and gazette notification. So every banker is supposed to read the newspaper every day. So if you see one of your company has when you see a notice published in the newspaper to liquidate one of your customer, a company, immediately that you have to go to courts and lodge your claim. When you are lodging your claim in a liquidation action, if you have a security collateral, we say the company land is mortgaged to the bank. So then the bank will be categorized as a secured creditor in the liquidation case. So in the liquidation case, the liquidation process is simple, very simple. If I say it's not simple, it's a complicated process. But if I say in simple manner, what will happen? The court will appoint a liquidator, a person called liquidator. So that liquidator, what will he do? He will get all the assets of the company into a pool, into a one pool. So that is called asset pool. Then he will sell all the assets. Then after that, from the money that he recovered from the selling assets of the company, will be distributed among the creditors. When he is distributing the the money to the creditors, there is a priority list. In the priority list, the creditors' priority list, government taxes comes to first, then EPF, ETF of the employees of the company, liquidated company, comes second, then the secured creditors. So if you have a security, you will be listed as will be listed in the third position of the creditors list. If you are unsecured creditor, you will be listed in the last of the creditors list. So what will happen if company can't pay the taxes and the liquidator can't pay the taxes of the government by selling the company assets, maybe VAT or whatever? So then then thereafter, no one in the list will get any money. So even though you are a secured creditor in that sense, once the liquidation action is filed, you can't go for recovery process. Basically, you have to go through the liquidation process unless you get a permission from courts to carry out a separate recovery action by your own. You can't do anything. It is not legal then. Clear?
Yes, sir. Thank you.
Right. Okay. So any other questions?
Excuse me,
Yeah.
sir.
Okay.
In case of a disease of a dormant account holder, what will happen to the funds in his account?
Right. Dormant account. Dormant means there are no transaction for a period of time. We say 6 months. So what will happen to that money? So since it is not an abandoned property, you can't follow the abandoned property procedure. That means you can't send that money to the central bank. even it is a dormant account, dormant means there's no transaction, that money due to that customer. So in that sense, if it is less than 4 million, the legal heirs can claim the money directly from the bank. If it is over 4 million, the legal heirs, they have to go to courts and file a testamentary action and has to bring a court order. So same principle applies for the dormant account where when the customer is deceased. Clear?
Thank you, sir.
There was another question.
Yes, sir. I want to know now. You said that above 4 million, if a customer has a threshold of above 4 million, even deceased case, we have to go to a court order now. So, if the customer has given any nomination, will it be applicable?
Okay, those things actually it's a separate lesson, succession and all. Yes, since you asked that question, now I have to answer. No, so okay, if there is a nomination, nomination supersede everything. So if there is a nomination, you don't want to bother about the testamentary threshold and testamentary action, legal heirs or anything. You have to give that money to the nominee. That's number one. If there is a last will, last will, the legal heirs or the beneficiary of the last will has to go to courts and get a court order. Then we have to issue the money as per the court order. If there is no last will, then the legal heirs, they have to go to courts and file action, testamentary action, and has to bring a court order. Then we have to release the money to the legal heirs as per the court order. If the value of the property is below 4 million, then we don't want any court order. The bank itself can release the money to the legal heirs. So then what is the procedure? I already discussed. You have to get certain documents and you have to be satisfied that those are the people who the legal heirs are, and pay half to the wife or the widow. The rest will go to the children equally. So that is the procedure: nomination, last will, testamentary action, and succession without any testamentary. So those are the 4 ways that we can give the money of a deceased customer's money to the legal heirs. So I think I answered your question. Are you okay with that answer?
Yes, sir. Okay.
Right.
Understood.
Any other question? Okay, then I'll go to the next one. What is the situation if banker wants to terminate the contract? It can be terminated in accordance with the terms agreed upon the parties, banker-customer relationship. If it is a fixed deposit or safe deposit, terminates at the maturity. The banker nor the customer can terminate the agreement before the agreed date without the consent of the other party. For example, fixed deposit. If it is a fixed deposit, in fact, I discussed this previously also, so therefore I will not take much time. If it is a fixed deposit, it can be terminated before the maturity date only with the consent of the other party. If other party object, you can't terminate because you have agreed to keep that contract for a period of time. Either bank nor the customer can terminate the contract if it is a fixed deposit. If it is a current or savings account, the customer entitled to terminate the relationship at any time by drawing the funds and closing down the account. So that is the customer's right. What about the customer's right to terminate? It was discussed in the Bank of Baroda versus ASAA Mohammed. This is an Indian case. The customer demanded for the closure of his account, but the bank ignored the demand and continue the account. So what happened, this customer, he said, I want to close down my account, close the account. So he asked to withdraw the money and close the account, but bank didn't allow him to close the account. So then he went to courts. And his argument was, I have a right to close the account, but bank didn't allow me to close it. So that is a breach of banker-customer relationship. So court held that the cause of action arises from the demand. So court said, once the customer demand to close the account, if bank does not meet the demand, that means if bank doesn't allow the customer to close the account, that is a breach of contract. So therefore, customer can sue the bank and ask damages. So that is with regard to the customer's right to terminate his account at any given time. So if bank wants to terminate the account, what is the situation? Bank has to give a reasonable notice to the customer. So you see, I have bold this and underline two words, reasonable notice. In other words, the bank cannot terminate the banker-customer relationship at any time. So basically, the bank has to give a reasonable notice to the customer. Reasonable notice to the customer. What is reasonable notice? So in this point, a legal point has been discussed in this case. Prosperity Limited versus Lloyd Bank Corporation, Lloyd Bank Limited. In this matter, it was decided the account could be closed only by giving reasonable notice in the view of the cause of reasonable notice. So the court said bank has to give a reasonable notice to the customer. Reasonable notice. What do you mean by reasonable notice? When we say reasonable notice, the bank should give a reasonable time period to the customer before you close the account. So what is the reasonable time period, which is not described in any act or any law? So reasonable time that the bank has to decide. How do you decide the reasonable time period? Reasonable time period you have to decide as per the Prosperity Limited versus Lloyd Bank Limited case in the view of the course of dealing of the account. So basically, the banker, when we decide the reasonable time period, we have to consider certain points. That is, number one, the nature of the account. Number two, the nature of the customer. Number three, the nature of the previous transaction. Three things that we have to consider before we decide the time or reasonable time period. Number one, the nature of the customer. So we have to see whether this is an individual customer, whether this is a corporate customer. If it is a corporate customer, what type of corporate customer, whether it's a partnership, whether it's a proprietorship, whether it's a limited liability company, or whether it's a private public company, or whether it's a government entity. Likewise, we have to think about the customer, the nature of the customer. So basically, in other words, the time period that you give to a individual customer may not sufficient when it comes to a corporate customer. So if you give 7 days notice to an individual customer, will not sufficient. 7 days will not sufficient to a company, a customer. For example, we say we have an individual account and also we have another corporate account, a big company, public company. So if you are going to close down the public company account, you have to give reasonable time. It could be sometimes few months, 3 months, or whatever. A bank has to decide based on the customer's nature. That is number one. Then the second one, type of the account, whether it's a savings account, what type of account, what is the nature of the account. It could be a savings account, it could be a current account, or it could be a fixed deposit, right? If it is a fixed deposit, of course, you know that you can't close the account unless customer give his consent. So therefore, that is number one. Number two, if it is a current account or savings account, you can close the account, but you have to give reasonable notice. If it is a savings account, it's the matter of just releasing the funds to the customer, no harm. So he can basically go to any bank and open another savings account and put this money. So therefore, maybe a 7 days notice, even 3 days notice, or 7 days notice, or 48 days notice will be sufficient in that case if it is a savings account. But if it is a current account, then you have to think very prudently, because the current accounts is, the account holder can issue checks from the current account. So if you close the current account by giving a notice, very small period, so what will happen? All the checks that he has issued by now will get returned with the narration account close. So that will create a huge impact on the customer. So therefore, when we are giving notice to close down a current account, we have to give a longer period. So why we give a longer period? The time period is important because the time we give to him is him to arrange an alternative. Arrange an alternative means, if it is a current account, this customer has to open a new account in a new current account in a new bank, another bank, and has to issue checks or replace the checks that he has already issued. So therefore, he needs time. So you know that if you give 3 days notice or 7 days notice or even 14 days notice, will not be sufficient to recall his all checks and replace them with new checks. So therefore, a reasonable time that you have to give, it could be sometimes 3 months, right? Or sometimes 6 months, because 6 months, within 6 month period, the checks get stale. So therefore, he can arrange a new account, a current account, to issue new checks to others, but it could depends on the nature of the account, whether it's a savings account, whether it's a current account, whether it's a fixed deposit account. Then the third one is a previous transaction, nature of the previous transaction. So that also we have to consider that when we are giving notice to the customers before we closing the account. So if it is a savings account, you know that there is no way that he can issue checks. Only thing that he can do is deposit money and withdraw money. So when you looked at the transactions, you can see what type of transaction happens. If it is a the account that he has opened to credit his salary, then you have to give him a reasonable time to open a savings account in another bank and make arrangement with his employee to send the money to that bank, and for that you have to give a reasonable time period. So it could be a savings account of a professional. So then you have to give more time to him to open another account in another bank and take this money and go and deposit that money in that account. For that, he want to reconcile his account and all. So he need little time. So that is about the previous transaction of a savings account. If it is a current account, you have to see the number of transaction happen, or average transaction happen during a day or during week. So if you see in a current account where you see average transaction per day 100 checks issued by the customer or check cleared from this account, it's a very active account. So in a case like that, you need to give more time than a normal current account, where you get 1 or 2 checks occasionally paid or issued from that account. So therefore, it all depends on the the nature of the customer, on the nature of the customer, of the nature of the account, and of the nature of the previous transaction. So basically, the banker has to decide the reasonable time period. Based on that, if your judgment is wrong, then it will be unreasonable notice. The banker's decision then can be challenged in court of law. So any questions from up to here? Okay, if you don't have questions, then I will go to the next one. After termination, what will happen? So after termination, the banker-customer relationship comes to end. So as we discussed previously, when the banker's customer relationship, it's a contractual relationship. When the banker customer relationship comes to end after terminating the account or after closing down the account. So banker customer relationship start at the time the customer opened the account. It comes to end when the account is closed down. So then that is how we create the banker customer relationship and how we stop the banker customer relationship. But the duty of secrecy is extended beyond the point where the account is closed. So this is an exception to the contract law, because under the contract law, once the contract is terminated, parties, they don't have duties towards each other. But when it comes to the banker customer relationship, it has an exception. The exception is, even the banker customer relationship is over by closing the account, the duty of secrecy cast upon the banker will prevail. So basically it continues. So therefore, even after closing the account, the banker cannot divulge any information of the customer to a third party without the consent of the customer. Then does not affect the validity of the customer's claim in respect of the unauthorized debit made by the bank. So what does it mean? It means, if I explain this, we say the banker has, there's a banker customer relationship. Customer is maintaining an account in the bank. We say it's a current account or even a savings account. But the bank officers, they have done a mistake. We say that bank has wrongfully taken the money of the account of the customer. So after that, the bank closed down the account. Bank closed the account. So the question is whether the customer can recover the money from the bank, because the question is, now the banker customer relationship is closed because or terminated because the bank has closed the account. The answer for that is his validity of his claim in respect of the unauthorized debit made by the customer will not affect just because the bank has closed down the account or terminated the banker customer relationship. So that is another exception that we have under the banker customer relationship. So that is the effect of the termination of the banker customer relationship. What are the after effects that we discuss? It continues the duty of secrecy, and customer can claim any unauthorized debit done by the bank even after the account is closed. Any questions here? With this, we finish the banker customer relationship and the entire lesson. As I told you, it's a crucial lesson. Definitely there will be one or more questions from this. If you have any questions that you can ask now. Any questions?
So I have a doubt.
Yes, please ask.
If a current account holder dies suddenly, what will happen to his valid checks and the account?
Okay, I got your point. You say the customer has issued checks. Before those checks presented for the payment, customer has died. Question is whether we can pay the checks. Answer, no, we can't pay the checks. Basically, as I told you before, the account comes to end, or the banker-customer relationship comes to end from the point the customer deceased. Right? We say the customer died in 1st of August 2021. From that point onward, the account is not, or the banker-customer relationship is terminated. It is not legally valid then thereafter by effect of the law. But we don't know whether the customer has deceased or not. So we say that that news or that information came to the bank, we say yesterday or today. So then only we can terminate the banker-customer relationship or seize the account, or otherwise we don't know, we don't have the knowledge. So then what happened during this period, 1st of August to today, if we have paid checks, what will happen to those checks? So in court of law, until that the news or the knowledge came to the banker of the death of the customer, the transaction happened in this account is legally valid. So in other words, court will accept. If the news or the knowledge came to the banker, from that point onward, whatever the transaction that we have done in the account will be null and void. So basically, if you have paid the checks after knowing the customer is dead, then those payments are wrong. We have to return that money to the account, and we have to advise the legal heirs to go for a legal action, that is a testamentary action. So in the testamentary action, the people who got checks from the deceased customer can claim that value from the testamentary action. Clear?
Yes, sir. Thank you.
Okay. Any other questions? Okay. So since no questions from termination of banker-customer relationship, I believe everyone clearly understood the banker-customer relationship. I actually discuss subtopics. I have organized this lesson in a manner where you can easily understand and remember the law relating to banker-customer relationship. So if I summarize this, we discuss subtopics under the banker-customer relationship. We discuss who is a banker. Then we discuss what is banking business. Then we discuss the nature of the banker-customer relationship. Then we discuss the types of banker-customer relationship, different types of banker-customer relationship. And also, under the banker-customer relationship, the banker's rights and duties. Then we discuss the customer's rights and duties. Lastly, we discuss the termination of the banker-customer relationship and effect or legal the effects of the termination of banker-customer relationship. So if you study these topics well, I believe that you will be able to answer any questions, any question which comes from this area. Apart from these, that you have to remember certain cases that I gave you. So consider that also. You have to remember those cases and the judgments of those cases. Right. So then next, we are going to start a new topic today, that is securities or collaterals. Securities and collaterals. Okay, we'll start this new topic. What is a security or what is a collateral? So why do we take a collateral? Security or collateral we take to secure the risk of recovery of a loan or a facility. Now, when we are lending money, before we lending money, there's a process in the bank, and as per this process, every bank they evaluate the customer. When we say evaluate the customer, they are evaluating the repayment capacity of the customer. If customer has a very good repayment capacity, sometimes or most of the time bank lend to the such customer without any collateral or security. Sometimes we call it name lending, so that the person has a name in the industry or the banking industry where he has never defaulted the loan. He is a multimillionaire, so whatever he has assets, and we can 100% rely on his trustworthiness and credit capacity, right? So therefore we lend money without any security or collateral. But in some cases, after evaluating the customer's financials and past history, you observe that his repayment capacity is not so good or doubtful. So in a situation like that, to mitigate the risk, you can't avoid the risk. To mitigate the risk, what we do, we take collaterals. Collaterals we take in case of default of the customer. What we do, we liquidate the assets of the customer, which kept as the security or collateral, and we recover the loan and the interest and the charges from those assets. That is called security or securitization. So, the legal word that we use is collaterals. But in the banks, when I talk with the bankers, especially the bank officers that comes to meet me and for the cases, they refer the word security or security documents in generally in a wrong manner. So, for example, when I ask what are the securities available, they say the loan agreement. Loan agreement, they say it's a security document. Of course, that is a general general usage that we day to day that we use in banking sector. But when it comes to court of law, remember, or court of law of banking or law of common law, the security means the collaterals, right? The loan agreement or overdraft agreement, mortgage bond, mortgage bond is a collateral. Security document, offer letter, security, loan agreement, overdraft agreement, short-term loan agreement. Those agreements is not considered or are not considered as a collateral. Actually, the collateral is mortgage bond, promissory note, guarantee, pledge document. Those are considered, or those are the actual the security document or the collaterals that we held when we are granting facility. So other documents are contractual documents which support the collateral, right? So yes.
Sir, we didn't discuss about the different forms of bank and customer relationship.
I'm sorry, is that so?
Yes, sir.
So with this, our slides are over. No, which one you are referring?
Sir,
Okay, first part, right? Okay. This part, right? Actually, I have already discussed this part in general. Right. Sorry about that. I may have missed this. Okay. I will run through this the first slides of the today's lesson. However, these most of these are covered before when I discussed the banker-customer relationship and the banker and customer's right and duties. Anyway, I will take little time and I will explain this to you. The relationship between the banker and its customers can be broadly categorized into two categories. That is general relationship and special relationship. The general relationship of the banker-customer, if you get a question like that, it is a debtor and creditor relationship. Debtor and creditor relationship. In single, we call Naya Karu Saha Naya Himi Sambandhataya. So basically, when you take a banker-customer relationship, it's a contractual relationship based on debtor and creditor capacity. Now say customer open an account, he deposit money to his account. Now, in a situation like that, who is the debtor, who is the creditor? When the customer opens an account with the bank, he fills and signs the accounts opening form. By signing the form, he entered into an agreement contract with the bank. When the customer deposits money into his account, the bank becomes the debtor. So basically, when he deposits money, bank is the debtor. When the customer, it's like the customer has lent money to the bank. When the customer demand, the bank is obliged to pay. So the debtor is the bank and customer is the creditor. We'll take the other scenario. When the bank grant a loan facility, a loan or whatever the banking facility or financial facility to the customer. So then the lender is the bank, borrower is the customer. So then it changed. Then when a loan is granted, then the bank is the creditor, customer become the debtor. So that is the general relationship between the banker and the customer. Then after that, there can be a special relationship between the banker and the customer. Most of these relationships I have already discussed with you. Now the one type of special relationship is the banker as a trustee. So who is a trustee? Trustee is the holder of property on behalf of the beneficiary. The customer keeps certain valuables in the or securities with the bank for safekeeping or deposit certain money of specific purpose in the bank. So when he deposit money to his account or when he take a safety locker facility from the bank, he keeps valuables with the bank. So bank has to keep that property or the goods or the money as a trustee on behalf of the customer. So the customer is the beneficiary, bank is the trustee. This is a trustee and beneficiary special type of relationship under the banker-customer relationship. Then there is another relationship called bailor and bailer, bailee and bailer. So this is little bit I would say more legal terms, right? So bailee and bailer relationship is based on the bailment. The bailment is a delivery of goods by one person to another person for some purpose upon a contract. When the purpose is accomplished, the property to be returned to the person returned. The person delivering the goods is called the bailer. The person whom the goods are delivered is called the bailee. Now we take a situation like this. We say the customer obtained a loan and he kept his title deeds with the bank. you get the custody, or you can take the possession of the security documents, or rather title deeds of the customer as a collateral, and you keep the possession of those title deeds in your hand. So now what is this relationship? Now this title deeds kept with the bank based on the bailment relationship. The customer gave this title deeds for a purpose. So the property is, the goods is delivered for a purpose, and the bank is holding this property for a purpose, and the purpose is accomplished. That means if the purpose is served, the then bank has to return that goods to the customer. Now, for example, he takes a loan, we keep the title deeds. Once the loan is paid fully, we have to return that security or collaterals or whatever, or the title deeds back to the customer. So until such time, we are holding this the goods or the title deeds under the bailment as a bailee. So that is called bailee and bailer relationship. The person to whom the goods are delivered is called the bailee. So therefore, the title deeds are delivered to the bank. So the bank is the bailee. The bailer is the customer who gave the title deeds to the custody of the bank. So banks obtain tangible securities. In some cases, physical possession of the securities, goods, valuables, bonds, etc. are taken. While taking the physical possession of the securities, the bank becomes the bailee and the customer becomes the bailer. If you are unable to return the goods at the end of the contract, that means after accomplish of the purpose of the contract, then you are liable. For example, we say we got the security documents into your hand. This happened in normal day-to-day banking business. I have seen this. We take the possession, we take the title deeds and plans into our hand, and we give him a loan. So we say it's a 5-year loan. After settling the loan in 5 years' time, when the customer asks his security documents, sometimes we can't locate the security, rather title deeds and original plans and deeds. So then the question is whether we are liable. Yes, we are liable because we are holding those security documents or collaterals or title deeds or plans under the bailment. We are the bailee. If we are unable to return the property back, we are subject to pay damages to the customer. Sometimes it could be millions, right? So therefore, the bailee and bailer relationship is very crucial relationship, crucial special type of relationship between a banker and the customer. Then the lessor and lessee, it's not a new thing, you know. Lessee and lessee relationship is based on the lease contract. The lease of property is a transfer of the right to enjoy the property for a period of time in consideration of the price paid or promise. It's like this. Now take a lease facility, right? You as a bank, sometimes we provide a lease facilities for the customers. So lease means that we are leasing or we are giving the right to enjoy the goods or equipment which belongs to us to the customer. So customer during this period, lease period, he can enjoy, he can possess and enjoy the equipment. So if it is a car, we say if it's a vehicle in lease. So we are the absolute owner. Bank is the absolute owner. It's our property, our vehicle, and we give that vehicle to the lessee to enjoy the possession or enjoy the vehicle. That means he can basically keep the vehicle and run during that period. But after the end of the period, actually, that he has to return that asset to the bank, because it is the asset of the bank and it is given under the lease. So that is called lessor and lessee relationship. Then agent and principal relationship, I have already discussed in several locations. So you know, the bank act as an agent when we are giving instructions, when we are giving when we are collecting checks on behalf of the customer, when we are paying checks of the customer, when we are collecting money to the customer, for the customer to his account, when we are giving advisors, legal advisors, we have sorry, not legal advisors, actually financial advisors. So every occasions that the principal is the customer, the bank is the agent, principal can give instructions to the agent, so therefore the customer can give instructions to the agent, that is the bank. The bank has to abide by the instructions of the customer, and the bank has to act according to the instructions of the customer. So that is the agent principal relationship. Then as a custodian, when we get custodian is a person who acts as a caretaker of something. The bank takes legal responsibility for the customer's securities. While opening an account, the banker becomes the custodian of the money. So what will happen if the customer open an account, if he deposit money, in one side we are a creditor, and on another side we are a trustee, and also we are a custodian of the money. So therefore, as a custodian, our duty is to safeguard the interest of the principal. So we are keeping the money on behalf of the customer, and our duty is, as a custodian, is to return the money when he demands. So that is as a the relationship, a special relationship of the bank under the banker-customer relationship is a custodian relationship. Then the guarantor, as a guarantor, what is our relationship as a guarantor? So we know that banks sometimes issue bank guarantees to the customers. We are giving a guarantee on behalf of our customer. So in a situation like that, the bank becomes the guarantor. It's a guarantor relationship. Banks gives a guarantee on behalf of the customers. Guarantee is a contingent contract. So in other words, the banks has a contractual relationship with the beneficiary of the guarantee contract. Banks gives a guarantee on behalf of the customer. In case of customer default, the bank has to pay the bank guarantee. So that is under a bank guarantee, there's a special type of relationship between the banker and the customer, that is the guarantee relationship. As a guarantor, the bank has a liability. So those are the special types of relationship between the banker and the customer, or banker's special type of relationship. If you have any questions, you can ask from that, because I don't think that you have any, much questions on this topic, because I have several occasions discuss this special type of relationship. Any questions anyway? From there? Okay. Yes, any question?
Sir, I have no questions regarding that part, but
Yes.
There's a tute in the portal negotiable instrument. I think we did not discuss that tute also.
I didn't get. Can you repeat the question?
Sir, in our Google Classroom, there was a tute naming the negotiable instruments.
Okay.
I think we have not discussed that tute also.
Actually, we have not discussed any tute yet. Those tutes are there. You to do your revision part, you can answer to those questions. Tutorial discussions we will held separately. We will have a revision class also. After discussing with the institution, we will arrange a tutorial discussion class separately. Okay, after I finish the theory part. Okay.
Sir, I think that is the theory part.
That is not an exam paper discussion, sir. That is also kind of a tute. That's as we miss the sessions.
Is that so? There's a you say that the tutorial has been circulated, and we have to discuss that.
Yes, sir. There is a topic called instrument of negotiable.
Negotiable instrument.
Yeah, negotiable instrument. So
That's
that part we
theoretical
didn't.
part.
Yeah, that is we did discuss. That's
Okay.
that
Right.
we
So
came to tell that.
okay. So negotiable instrument part we will discuss after this. We discuss checks. We discuss not yet. No.
Next we have discussed on 22nd.
Right.
Not
So then
22nd. The previous week we had a class on.
Right.
I think I can't remember the date, but we have discussed that.
So then the bills of exchange we never discussed. No.
No, sir.
Right. So that we will discuss. Shall we discuss after the securities lesson? That's okay, no? Right?
Yes, sir.
Right. So just thank you for. Okay, I may have missed that part. Then the bills of exchange and negotiable instrument that I will cover after the securities and securities lesson. Okay, that means we say next week. We'll do that. Okay. Right. Since I have started this one today, the securities, I will continue with that. If you don't have any questions from the special type of relationship of banker-customer relationship, then I'll go to this one, the securities. We were discussing about the securities. So I explain you what
Sir,
is
sir,
yes.
this tute also not available in the portal.
It is not available because I think it's not circulated. Only today that I am sending this. I will ask the institute to. You can see the slides, no? Can you see the screen?
Yeah, yes,
Yes,
sir. We
sir.
can see.
Right. So then I will ask the institution to circulate among the students. Okay.
Okay, sir. Thank you.
Right. Okay. So right. So securities or collaterals, that I explain you what is a security or collateral. Why we take a collateral? What is the purpose to have a collateral? So on. So we'll see. When we say the collateral of securities, I said we take a property basically as a collateral or as a security. When we say properties, what do you mean by a property? What are the types of properties that we can take as a collateral or as a security when we are lending? So there are three or rather four types of properties are there according to the law. That is immovable property, movable property, tangible property, and intangible property. So this is the classification that we can give for the properties. Immovable properties means the property that you can't move. Example, land. Movable properties that you can move from place to place. Example, vehicle. Tangible property means the property that you can touch. You see, when we say tangible property, it includes movable and immovable both. For example, land is a tangible property. Land is a tangible. You can touch and feel the property. You can touch it. tangible. So if you are asked to explain what is land, land is a immovable tangible property. So vehicle, we say car is a tangible movable property. It's tangible, you can touch, and also it can be moved from place to place. So that is another third type of property is tangible. What do you mean by intangible property? Intangible property means that you can't touch it, you can't feel it, you can't hold it. However, it's a property where you can take, it has a value, and you can keep that as a security or collateral to borrow. Example, goodwill of a bank. We say Coca-Cola, it's a business name which has a huge value. That can be mortgaged, that can be transferred, that can be sold. Likewise, that can be leased. So it has the features of a property, even though you can't touch it. So goodwill or the business names are intangible properties. Intangible properties. So basically, movable properties, immovable properties, tangible properties, and intangible properties. All these types of properties can be taken as a collateral when you are lending. So that you have to remember, it's not only the lands, not only the vehicles that we can take, even intangible properties also that we can take as a collateral. We are taking actually intangible property. For example, book debts. When we say book debts, it's not a tangible thing. It's intangible. It's in the records of a company. But we take that we take the book debts as a collateral. We take a mortgage on a book debts, and we lend money, right? So these types of properties that we can take as a collateral. When we see when we take financial facilities that we give to the customers, that
Excuse me, sir.
Yes.
I was doubting the previous slide.
Yes.
As you informed, the intangible property as we can take the goodwill of the name. So,
Yes.
are we taking the company registration copy, anything? For that?
Actually, not that. It's a we can take, for example, we say you want to lend money to the we say Coca-Cola company, right? And they say, okay, we have a good reputation and goodwill. Coca-Cola is a brand name which has a very high value. So they say, okay, we'll keep the Coca-Cola name as a security. We'll mortgage that the right to you, and we want money. We want to borrow money. So then we take the mortgage. The name will be mortgaged to the bank. It's just a paper document. You take nothing. Actually, the company pass a resolution, and company directors sign a mortgage bond and mortgage the name or the goodwill of the company to the bank. So what will happen if they default? We claim the name. So thereafter, the Coca-Cola company cannot use the name, and also we can sell that name to another company or another person. So then what will happen? The Coca-Cola name then thereafter will be owned by somebody else. So that's how it works.
So excuse me, sir.
Yes.
Excuse me. Now, for accounting purpose, is there a specific way to calculate goodwill, value-wise?
Now, if you take you take now you go through the financials of Coca-Cola company, right? Audited finance or management finance, they always give a value for the goodwill. So it could be a millions, right? So you can do your own evaluation and see whether this name worth that amount. However, there's a way, there's a valuers that they can value the goodwill also. Likewise, that's the mechanism actually, or otherwise you can't, there's no the particular way that you can measure the value of the goodwill. It's actually allocated value or a given value. Clear? But of course, if it is a book debt, you can do a proper audit and calculate what is the actual book value and ascertain the book value and mortgage it, but at a given time. But when it comes to goodwill, you can't just you can't ascertain the correct value of the goodwill because actually it's not that possible to calculate the goodwill of a company, and the value that they have allocated to the goodwill reflect in their financials. From there we can take, and also we can do an independent valuation. The valuers, they have a mechanism actually that is not known to me. I don't know the accountants and them whether they know how to give a value to the goodwill, good name of a business. I am of course unaware how to calculate it. Okay.
Sir, is it practice in the Sri Lanka still?
Yeah, it is in the practice. It won't happen in regularly. Very rarely it happens because, you know, for example, I took the example Coca-Cola. The Sri Lankan Coca-Cola company actually can't mortgage that name to any bank because the Coca-Cola name belongs to the American company. They are the principal. Sri Lankan company is an agent only. So they can't basically sell, or they can't mortgage that to a bank unless the principal company gives their consent. So that is why it is not happening. But if it is a pure Sri Lankan company, we say Siddhalepa, right? Of course, if they want, they can mortgage the name and borrow money. But when, as you are aware, when we are evaluating the collaterals, our banks, they are not into take business name as a mortgage. Rather than that, we are prefer to take a immovable property, land or movable properties, because we know liquidation of immovable property or movable property is easier than liquidating intangible property. Now, for example, if Siddhalepa borrows money by mortgaging their name, if they default, we have to sell the Siddhalepa name. To whom we can sell the name? So there can be a lot of there can be a difficulty to find a buyer for that also. So liquidating for process is not easy if we take a tangible property as a collateral. That is why we are not taking tangible properties as a collateral very oftenly. But when it comes to book debts, that is a common security that we always take, because you can calculate the actual book debts, and also we can get an undertaking from the creditors to pay directly to the bank if in case of default. That is the practical situation. It is legally we can do. It's legally it's possible, but practically very rarely we do. I mean, intangible mortgages with regard to the business names and intellectual rights. Likewise, we don't much used to take as a mortgages. Clear?
Thank you, sir.
Right. So okay, these four types of for the time being, remember there are 4 types of properties. All these type of properties can be taken as a collateral, or we can take mortgage or lease or whatever the properties that these properties can be taken as a collateral. Then we were talking about the 2 types of the facilities that we give to the customers. That is, we have one type is securities, secured facilities. The other type of lending is unsecured facilities. Secured facilities mean the facility is backed by a collateral. Unsecured means there's no collateral, it's just a clean facility. So I have given here some examples. So without wasting much time, I will go to the next one. Secured facilities, you know, loans, ODs, secured by FDs, mortgages, guarantee bonds, pledge loans, we take stock in trade or book debts. Leasing, when you are giving leasing facility, we take the lease assets as a collateral. Hire purchase agreement or hire purchase facilities, again, we take the asset as a hire purchase asset as the collaterals. Pawn loans, we get the gold articles as a collaterals. So likewise, in different types of facilities, we have different types of collaterals, and the most I would say the best collateral that we can think is the money, FD. FD can be used as the best collateral when we consider lending. So then mortgages, we can take mortgages on movable properties and immovable properties. The movable property, as we know, the land and the things actually permanently attached to the land is considered as a immovable property. Movable property, the assets or the properties that you can take from place to place. So both movable properties and immovable properties that we can take as a collateral, and we can take mortgages on movable and immovable. So I have given here a small comparison of movable mortgages and immovable mortgages. We'll take the number 1 point. When it comes to movable mortgages, the documentation part is easy compared to immovable property mortgages. Immovable property, when we say immovable property mortgages, the documentation is difficult. That we are going to discuss the process later. So we'll see why we say it is difficult. If I explain that, right? If you take a movable mortgage, example vehicle, so we take the vehicle book, registration book, and we sign a mortgage bond, and then we register that mortgage bond in the RMV, Motor Traffic Department, registration of Motor Traffic Department, and the documentation part is then easy. But take immovable property land. So before, when we take a immovable property mortgage, it's the documentation part is very difficult because you have to check at the land registry, you have to check the valuation separately, then you have to execute the mortgage, then you have to register that mortgage in the land registry. Likewise, there is a process compared to registration and checking of title of a immobile property is difficult than compared to movable property. Then value. When the second point is value. Normally, the value of a movable property depreciate with the time. Normally, I said normally, under normal circumstances, that's happened. But if it is an immovable property, example land, the value appreciate with the time or against the time normally or under the normal circumstances. So, but however, due to under certain situations, this can happen in other way also. For example, now if you take a vehicle value today, see it has increased, right? You know how much is a registered vehicle now, since the vehicles import of vehicle has been seized. The registered vehicle market has gone up now. So in theoretically, what it should be depreciated. Now, for example, if it is a vehicle registered in 2019, by now the value must come down. However, now if you check the market, the price actually has gone up twice or more than twice. It has gone up because of the market condition. However, normally it has to be depreciated. It depreciates when it comes to movable property, but immobile properties value normally increase. Then the possession. If it is a movable property, even though we get a mortgage, for example, we say a vehicle mortgage, the possession of the vehicle is with the borrower or the customer. We don't take the possession. Immobile property, even though it is possessed by the customer, it is easy to take the possession or easy to locate the asset. Now, for example, if we take a mortgage over a vehicle, if customer default, customer can hide the vehicle. So then we can't take the possession. But if it is a land, of course, since you can't take the land from place to place, it is there. You can easily, the lender easily can locate the asset or the land. Then the risk involved. Next point, risk involved in a mortgage, movable mortgage and immobile mortgage. Considering the above facts, that is the depreciation of value and the possession, the risk involved in a movable property mortgage we consider as high risk. But when we consider the facts, the value appreciate and possession can be taken easily, the risk involved in immobile property, land mortgage, we categorize as a low risk when it comes to risk. Then next point, the recovery process. That is if customer default, what is the recovery process or what is the liquidation process of the asset? We have a recovery process in the mortgage bond of a mortgage bond of a movable property. There is a process that we have to go to courts and we have to get the possession, and we can resell the property and recover the loan. But when it comes to immobile property, we have special recovery processes or special recovery laws that we can apply, especially processes like parate, and we can auction the property and recover the loans. That is about the recovery process. Then examples I have given here. Actually, this has to change left and right columns. It's wrong that has been mentioned there. So movable properties, example, chattels and movables. On the other side, immovable property, example, land and fixtures and fittings, buildings, fixtures and fittings permanently fixed to the land is considered immovables. So that is about the movable mortgages and immovable mortgages. I have given a comparison. Sometimes you may get a question like this to compare the mortgage, movable mortgage and immovable mortgage, and do analysis on the mortgages, which one is better collateral. So that comparison is for that purpose. I have very briefly given here, so you can read more on these subtopics. Any questions from here? Mortgages of movable and immovable. Okay, so then I'll go to the next one. Now we'll take mortgage of immovable property. Mortgage of immovable property, land mortgage. We'll see what is the procedure that we have to follow when we are taking a land as a mortgage, as a collateral. We are talking about the land mortgage. This is very important. The steps that you have to remember, and the purpose of each and step you have to remember also. Right. Okay. we'll now going to discuss the process of taking land mortgage as a collateral. Now the first step, if customer offered a land as a collateral, what are the steps that we have to follow? First step is to do a title search. Number one, title search. We carry out a title search to ascertain the ownership of the property, of the land. Unless the property belongs to the borrower or to the surety or the mortgagor, that is a third party, on behalf of the borrower, if he wants to mortgage the property, that he should have the ownership of the property. The borrower or the third party should have the ownership of the property or the land. Unless you have the ownership, you can't mortgage. So for example, if I want a loan, I can't mortgage a property which is not belongs to me. So therefore, we as the bank first has to be satisfied if the property belongs to that particular borrower and he has a clear title chain for the property. When it comes to a land, it's very important to the value of the land depends on the title. If it has a clear title chain, at least over 25 years, it can be considered as a good title. So how do we ascertain the title? The title report or title search is basically done by a lawyer who has more than 10 years experience in notarial and civil practice. Remember, it's very important. Title search, first step is to do a title search and prepare a title report. The title report will be prepared by a lawyer who has more than 10 years experience in civil practice. Then how do we prepare a title report? The lawyer who prepares the title report has to examine the papers in the land registry. You know, when it comes to land, the deeds actually are registered in a place called land registry. So every area they have a land registry. For example, if you say Colombo, in the Colombo district, we have several land registry. We have Colombo land registry, we have Homagama land registry, we have Avisavella land registry, we have one in Nugegoda, Delkanda. Likewise, in the Colombo district, it has been divided into zonals. Each zone has a land registry. This Colombo zone, it has a land registry where it is situated in Colombo 7, near in front of municipal. In front of near the glass house. There's a land registry. So all the deeds related to the lands in this zone, Colombo zone, are registered in the land registry of Colombo. And then the land registry of Colombo, they have books called folios and volumes. In there, they register the deeds. So when a lawyer looked at these volumes, we call them extracts, right? You can see how this land has been sold or has been transferred from one person to another person. Likewise, you can go to the history and see the land for over 30 years, how the land has been, the ownership of the land has been passed to the present owner. Then you have to ascertain the title, and you have to see whether there is a clear chain of title without any encumbrances or any defect, whether the title has been passed from the previous or the previous owners to the present owner. If there is a clear chain of title over 25 years, over 30 years, then the lawyer will recommend the title to the bank. So that report is called title report. So that is number one. Then after taking the title report, if title is recommended by the lawyer, panel lawyer of the bank, then next thing that we have to do, we have to get a valuation report. So to prepare the valuation report, the valuation reports are prepared by the valuers. We have a panel of valuers. So then we contact the valuer, then we ask him to prepare the valuation report. So the valuation report, it carries two values basically two values on the report. It gives a market value of the property and the for sale value of the property. So these values or the valuation report is important to ascertain the value of the property. Because as we know, when we are lending, we take the collateral to secure the repayment of the loan. So not only the loan, interest and other charges should be covered from the value of the property. So therefore, when we are lending, we are not lending 100% of the value of the property. So basically, different bank have their different policies. However, normally it's 70% or below of the market value only we grant as a loan. So therefore, we say it's 100 million or 10 million market value property. Then the maximum that we lend is 70 lakhs or 7 million. So because we have to recover the loan and also the interest and other charges also. So then after ascertaining the market value and the for sale value, the third one, before we lend money, or we take an inspection report. The inspection report is prepared by the bankers. This is very important when it comes to the bankers. The inspection reports I have seen, observed, I have to say this, the bankers who have made most of these inspection report, they have no idea why they are preparing this inspection report. They just prepare an inspection report because they have to do so, or sometimes very negligent reports I have seen. So therefore, prevent doing that. Know why it is important. The inspection report is important in a certain situation to locate the property, especially when it is default. Inspection reports are prepared by the bankers. So basically, the person who prepare the inspection report should give the location to the property. So basically, from the branch to the property, how you access. So the directions that you have to write in the report. And another thing that you have to observe when you are writing inspection report, basically the bank officer has to visit to the location and inspect the property. This is very important. We have seen certain occasions the bankers, they write inspection report while they are in the bank. They don't visit to the location. Based on the information provided by the customer, the bank officers write inspection report from the branch. So that is actually not inspection report there, right? So it's just a report. So if it is an inspection report, you have to physically go to the property and inspect the property. So what are the things that you have to inspect, or what are the things that you have to observe? The one is the right of way. Right of way means the access road. You have to see whether this access road, whether it's a private road, whether it's a public road, or if it is a private road, the width of the road. Likewise, you have to see the right of way. And also you have to observe who is in the possession of the asset. If whether it's a bare land or whether it's a land with a building. If it is a bare land, if it is cultivated, if there are any crops grown there, or if it is so, who is cultivating the property? These things that you have to see, and you have to see who is actually in the possession. It could be a third party. So if it is so, then you have to write in your inspection report the details of the person who is in the possession. If it is a building, you have to see whether that has been rented out, or whether there is a tenant, or whether there is a lessee in the possession. If it is a residential house, you have to see whether actually the borrower in the possession or somebody else in the possession. All those things that you have to include into the inspection report. So that is the report number 3. Then after that, before we get the mortgage bond done, we have to get local authority certificates. These are the documents that the customer has to provide. Local authority documents, when we say the local authority documents, the main local authority documents that the customer has to produce to the bank are, number 1, the ownership certificate, non-vested certificate, street line certificate. Those are the main documents that he has to provide. Non-ownership certificate means at the relevant local authority, the customer has to register his name as the owner in the documents at the local authority institution. So then non-vesting certificate means that the customer has to pay all the rates to the local authority documents and get a certificate from the local authority. Or otherwise, what will happen? The local authority can pass a resolution and sell the property if the customer has failed to pay the rates. Then what will happen? Then if even though we have taken a mortgage, the local authority can sell the property to recover the rates. So therefore, we have to get a certificate from the local authority that is called non-vesting certificate. Then thereafter, street line and building line certificates also we have to obtain from the local authority document to see whether this property is worth to take as a collateral. Now, street line.
Excuse me, sir. I
Yes.
have a small doubt in this inspection, the local authority certificate. So
Yes.
before we buy the land, do we need to go and register the local authority certificate? If I am a customer?
No,
Because
no,
I am
no,
not
no.
working in the credit department,
Right.
so I don't know about it.
Right. Okay. It's like this. Now we say you are a customer, you want to buy a land and you want a loan from the bank, right? In a situation like that, your question is whether you want to get the local authority documents in your name. It is not possible, right? The local authority document will be released or will be given under the present customer's or present owner's name, right? That is the seller. So our customer is the buyer. So local authority documents will be released under the present owner's name. So the ownership certificate issued by the local authority should carry the present owner's name. So if you take cases, most of the time we see the local authority, the present owner may have not transferred the ownership to his name. So in the local authority, somebody else, that means the previous owner's name, goes as the owner. So in a case like that, the present owner has to transfer the name into his name at the local authority. For that, there is a special form called AT form. That AT form has to fill and submit to the local authority, and the local authority then transfer the ownership to the present owner's under the present owner's name. So the certificate of ownership will be issued under the present owner's name. So what we need is a local authority document, that is ownership certificate under the present owner's name, and also non-vesting certificate will be issued under the present owner's name, because he has to pay the rates up to date. So basically, likewise every document, local authority document, will be issued under the present owner's name. So after purchasing the property, then that will be you have to take steps as the present owner. Now after purchasing, transfer the ownership into your name and also other documents into your name. So that's how it works. Clear?
Yes, sir. Thank you.
Right. Okay. So then local authority documents, I said mainly 3 documents: ownership certificate, non-vested certificate, then the street line and building line. Street line and building line means street line in the plan, the local authority document mark the street line. Street line mean if they are going to expand the width of the road, facing road, then they will acquire the portion of the land. Then they will mark the street line. Then if street line is marked on the building, rather the plan, survey plan, that we know that one day the local authority can acquire that portion of land. So then we have to consider whether we are going to consider that area under the street line mark, whether we can consider that value of the area also for our purpose. Then building line mark in the survey plan, building line means from within that building line, no building can be constructed. So basically, so the buildings can be built after the building line marked in the survey plan. So those are for your information. So then
So in the inspection report, what is the ROW?
ROW means right of way, right? Right of way. That means the access road. You have to see whether it's a public road, whether it's a private road, right? So basically, sometimes you see on the plan, the surveyors, they marked a right of way. But actually, when you go to the site, you see there's no right road marked on the ground. So in a situation like that, you have to see whether actually there is a roadway. So especially these thing happens when they subdivide the lands, they mark roads. they don't, the surveyors, they don't go to the site and they don't survey the land. They just take the previous plan and they subdivide the plan based on the drawings. Actual situation, if you go there, you can't basically see a road like that. So that's why I say that we have to go to the location, we have to go to the site, and we have to observe whether the right of way actually in the ground or on the ground, even though it is marked on the plan. Clear? So then
Yes.
local authority documents, and also then we have to obtain approved survey plans. So survey plans also approved by the local authority documents. So when they approve the survey plan, they put a seal, and sometimes they put conditions also. These things that you have to be very careful if you are in the credit department. When you get the survey plan into your hand, see whether it is approved, see whether there is a local authority seal placed on the face of the plan saying approved or anumatai. So that wordings must be there, and also see whether they have approved the plan subject to certain conditions. If it is marked subject to conditions, that you have to be very careful. You have to see what are the conditions are. So if there are conditions that restrict the building of property or something like that, then you have to consider whether it is worth to take that property as a collateral. Then if there is a building in the property, that we have to take the approved building plan also. And also if it is a completed building, then we have to get the COC, certificate of conformity. That is also issued by the local authority institution. So those documents that you have to obtain from the local authority. And also if it is if the loan is given for the purpose of constructing a building, then we get a BOQ, bill of quantity. So that gives the expected expenditure for the building, because once the building is put up in the building in the land, the value of the building also added will be added to the mortgage. So that's why we take a BOQ also. So that is number 4. Then after obtaining all these documents, that is title deed, valuation deed, inspection report, local authority, approved survey plan, approved building plan, BOQ, then if all these things are in order, then we can take that land as a mortgage, as a collateral. Then we can execute the mortgage bond. So when we say executing the mortgage bond, as per the Prevention of Fraud Ordinance and the Notary's Ordinance, the mortgage bond has to be executed by a notary. Executed means that has to be signed by and attested by a notary. So therefore, it is a deed. The mortgage bond is a deed attested by a lawyer or notary. So you may have seen that when we are getting a mortgage, you go to a lawyer, and the lawyer prepare the mortgage bond, and the mortgagor and 2 witnesses has to sign, and thereafter the lawyer sign. Then you pay the stamp duty. Then the lawyer will attest the mortgage bond, and after that register that mortgage bond in the land registry where the title deeds are registered. Apart from the mortgage bond, we take another document called 47A declaration. 47A declaration. it is another deed attested by the lawyer, same lawyer. At the time of we taking the mortgage bond, we take 47A declaration also. Can anyone say what is 47A declaration, or have you ever seen a 47A declaration? What is the effect of the 47A declaration? Anyone knows about this? Okay, no one knows. Okay, so 47A declaration means now mortgages are governed by Mortgage Act number 6 of 1949. So as per the Mortgage Act, if in case of default, the mortgagee, that is the bank, can sell only the mortgage property, So if you can't recover the loan from selling the mortgage property, you can't sell the other properties of the mortgagee. So therefore, we take a declaration from the mortgagee saying that he gave his consent to the bank. In case of default, other than the mortgage property, the bank gets a right to go behind the other properties of the mortgagor. So that document is called declaration, 47A declaration. Then the mortgage bond we register at the land registry. Then title, that is the way that we do the registration part. So I think it's now 3:07. I believe that you have another class today, no?
Yes, sir.
Okay, so in that case, we'll stop at this point. So title registration and other part, we will start from there on next day. Any questions if you have up to now regarding mortgage of lands, you can ask.
So I have questions, sir.
Yes.
So what is for sale value, sir?
Okay. At the valuation report, we take two values, the market value and the for sale value. Market value is the value that you sell the property on the open market. So that means, so if you want to sell a property, you advertise the property and you wait and you get the maximum price from the bids. So you can wait easily. You can wait 1 month or 2 months or whatever time until you get the best price, because lands are not a perishable item, right? So therefore you can wait. But for sale value means if you want to sell the property immediately without waiting much time, if you want to sell, get the money quickly, what is the maximum price that you can take in a short period of time? That is called for sale value. So without waiting till the best price, if you sell the property on auction, what is the maximum that we can get, or what is the maximum price that we can expect if in a quick sale? So that is called for sale value. There is a method that to discuss, the valuers know that knows the method, but remember that is if you sell the property without waiting much in a quick sale, the maximum price that you can get, that is called for sale value. For sale value. Clear?
Thank you, sir.
Right. Any other questions?
Sir, there's one question.
Yes.
Let's say that banks are going for secondary and tertiary mortgage bonds or the same property. So what is the requirement of having secondary or tertiary mortgage bonds without increasing the same bond?
Okay. Right. Okay. Since you asked that question, it's like this. When we are taking mortgages, there are several types of mortgages. The one type is you get a mortgage, it has a value, and you lend that the value. Then if you want to give another loan, you can't increase the the mortgage because it is not a floating mortgage, right? So in the second, if you are granting another loan, at that time you take another mortgage on the same property. That mortgage is called the secondary mortgage, right? We say that initially the customer requested 5 million loan, right? At that time customer didn't have any intention to get another loan, so he get a loan for 5 years, and now for that purpose he gave a mortgage bond, and we executed the mortgage bond for 5 million, and we say we granted them 5 million also. Now after 3 years, now he wants another loan. He requests for another loan, he applies for another loan, he say, okay, I'll give a mortgage again the same land. So it's a totally new loan. We give 3 million this time, and we take a mortgage. It's a 3 million mortgage separate from the previous mortgage. There's no continuation, or there's no direct relationship between previous 5 loan and this loan, right? So therefore we take another mortgage for 3 million. The second one is a secondary mortgage. Now after we say another 3 years, this same customer, he wants another loan because he has not completed his house. Now after 3 years, he asks for another loan. So at that time, we give another loan of 2 million and getting a mortgage on the same land. This third one we call is treasury mortgage. So third one is that. So that is one method that we can do, because one method. The other method is, at the time of we are granting the first loan, the customer and the bank, we agree to have a floating mortgage. Floating mortgage in the sense, the bank or the request of the customer can increase the or top up the mortgage. We say we marked a limit. We say we get a mortgage for 5 million, and customer, we release 5 million to the customer. We have pre-arranged a pre-arrangement with the customer. The customer, after 2 years, he wants to increase the mortgage limit. So then we get a additional mortgage, increasing the value of the mortgage from 5 million to 8 million by increasing 3 million. So that is another method that we can take. So it depends on the arrangement between the bank and the customer. Clear?
Okay, so let's say this that one customer is obtaining a loan to purchase a bare land,
right?
And we have a primary mortgage bond over the same property. So
Yes.
after 5 or 6 months time, he's asking for a secondary loan in order to meet the construction cost.
Yes.
So what is the best option to go for a secondary mortgage or enhance the bond limit?
The best option is go for if it is the same bank, it doesn't matter if it is the same bank, because if it is the same bank, whether you have primary mortgage and secondary mortgage, you can if the loan is default, if either loan is default, you can call both the mortgages, cancel the both mortgages and sell the property. But in a situation like this, we say that he took a loan from the bank A to purchase the land, and he take a loan from another bank to construct the property. Then the second bank will have the secondary mortgage. So then the position of the secondary mortgage holder bank is weak, because first you have to satisfy the primary mortgage holder, then the secondary mortgage holder. However, if it is the same bank, the advantage of having increased loan is, in case of default, it is a one loan, right? So therefore, you can just go parate or court of a mortgage bond action because it's a one loan. You top up the loan. You give 5 million, then you top up that loan up to 8 million. It goes as a one loan. But if those are two loans, one is 5 million, the other one is 3 million, separate loans. We assume that he is serving one loan without any default, and he default the other loan. So we say the secondary mortgage loan is default, the primary mortgage he has paid without any default. Then we have a problem. So how to recover that? What we are going to do? So these are the practical situations or practical issues that we face when we grant primary and secondary mortgage. In that case, the best option is to give a top-up loan. That is by increasing the mortgage. Clear?
Okay, thank you, sir.
Any other questions? Okay, I think the time has passed now, so we'll stop at this point. So next day we will continue from here. So thank you very much for your participation. We'll meet on next Saturday again.